Good evening, guys. So, the CA Foundation first exam, the law exam, just got over 5 o'clock. It's been a couple of hours since it got over. First of all, I'm very happy. Yesterday, we had released a video predicting the law paper for today. 80% of the topics have come true further from the prediction. So I hope students really, could use the previous video and could attempt the exam well today. I am sure a lot of students have anxiety as to how the law paper went. So this video, I am going to quickly discuss the solutions for today's law exam paper so that you can get an idea of how it went. But mind you, even though I'm discussing the solutions, please, if your answers are good, matching, great. If not, don't get disheartened. Just go ahead with the preparation with for the next exam. Don't dwell too much on how today's paper went. But just to give you an estimate, I'm making this video to tell you what are the correct answers for the questions. Let us begin. So in law, mind you, what matters? People think section numbers matter. No. Section numbers, okay, but you will not get marks just for mentioning section numbers. What matters the most is logic. Number two, using the keywords. So I will tell you three things for each question. What is the answer, what is the logic, and what is the keyword to be used. With that, you can compare what you have written in the exam, whether you have written well or how it went. Great. Chalo, let us begin. Also, most of the questions are from yesterday's prediction. Okay, so let us begin with the first question now. Okay, let us start. Okay, so question number 1A. So 1A was about a court matter, correct? So there was one person who is basically offering a judicial officer, promising to offer a judicial officer some sum of money so that he can drop the case. That is the scenario. This question was predicted yesterday in the video. So this concept is basically about void contracts, and this particular contract falls under agreements which are opposed to public policy, and within that specifically the keyword is interference with court of justice. So basically, also we also call it as public office, trafficking of public office. But more than so you can use this word also called trafficking of public office, but the key word here is agreements which are opposed to public policy are void, and it is also interfering with court of justice. Correct. So what should be the answer? See the final question. Okay, whether Mr. C can recover the amount promised by Mr. X. So answer should be no, he cannot recover. Why? Because this is a void contract. So Mr. X has promised to pay money to Mr. C, correct, for dropping a case. He's a judicial officer, so this is against public policy, it's void. So answer is no, he cannot recover money. What's the logic? Logic is void contracts cannot be enforced, so you cannot recover. Why is it a void contract? Because it's an agreement opposed to public policy and it is interference with court of justice. So that is question number 1A. Let us move on to question number 1B. So in 1B you had to find out whether it's an associate company or not. First of all, what is the definition of associate company? 20% voting right or 20% shareholding. When we say shareholding, it includes paid up share capital and your convertible preference share capital. In the question, just to confuse you, look at the question. They have given some non-convertible debentures. We don't care about non-convertible, so we only see convertible portions. So here there is no convertible, so I'm taking paid up capital of 15 crores and total paid up capital of 100 crores. So 15 by 100 is 15%, not touching 20%. So it is not an associate company. So first of all, when they say define associate company means you have to define that it has 20% voting right or 20% shareholding. Basically the key word here is significant influence. A company can significantly influence the other company, still it is not a subsidiary company. How to determine it? Up to more than 20% but less than 50%. Correct. Majority shareholding is not there, it is not subsidiary. Even joint ventures fall under associate. That is the definition of associate. In this particular case, to check the 20%, we don't see non-convertible portions, either paid up share capital equity or convertible preference share capital. So here convertible, nothing is there given in this question, everything is non-convertible, so ignore. So we just have 15 by 100, 15%, not touching 20%. So here they said ABC Limited and XYZ would be called associate company. No, it is not an associate company. 20% is not there, significant influence is not there. That's the answer for 1B. Let us go to 1C. Again, 1C, we predicted this question. KV attempter was there in the yesterday's video prediction. Okay, now KV attempter, they asked 4 exceptions. There are many exceptions, you can write 4 of them. I'll tell you any 4. Sale by description, sale by sample, or sale by usage of trade, or condition as to fitness, as to quality, when you're depending upon seller's judgment. So these could be some cases which you can mention. For KV attempter, they did not ask the definition of KV attempter, they straight away asked you exceptions. So straight away you can mention some of these exceptions. So if I give you a description and if it's not matching with the description, your product, how can you blame me? You cannot say let the buyer be aware. Correct, it is seller's mistake. I gave you a sample, it's not matching. You cannot blame me, buyer be aware. No, it is seller's mistake. Similarly, you deal in a particular type of products and I am buying that particular type of product. It should be useful, it should be fit enough, the quality should be good enough. Correct? If it is not, and also when cases where I clearly told the seller why I am buying and I bought it and that particular good is not fulfilling that purpose, again, how can you blame the buyer? You cannot say let the buyer be aware. Again, seller's mistake. So these could be exceptions. So exceptions are what? Sale by description, sale by sample, sale by description and sample, then usage of trade. Correct? Then quality as to the fitness, if we are relying on seller's judgment. These are exceptions. Let us go to now question number 2A. So in question number 2A, we have misrepresentation and fraud. Again, this was predicted in yesterday's video. So misrepresentation and fraud, and what is the difference? So fraud is intentional deceit. Misrepresent is you are not intentionally deceiving people. You yourself are thinking something which is wrong and you are just communicating that, correct, to the other party. So there is no intention to deceive, but still the other party got deceived because you misrepresented, because you yourself thought something to be true and told them which is not true. That's a misrepresentation. So fraud and misrepresentation, what is the difference? Fraud has an intention, misrepresentation does not have an intention to cheat or deceive, but both of them fall under voidable contracts only. That is the key thing. Okay, why they both fall under voidable contracts? Because consent, free consent is not there. Both of them show lack of free consent. That is your answer. Let's go to section B, that is 2B. Circumstances where LLP may be wound up. Again, yesterday we have predicted this question. We said winding up by courts. Tribunal is a court. So when can a court shut down an LLP? There are multiple conditions. Example, if an LLP is continuing for more than 6 months without having 2 partners at least, so the number of partners has gone below 2 and that state continued continuously for more than 6 months, court can dissolve it. Next thing could be for continuously 5 years LLP did not file its annual returns or accounts or statement of solvency, court can dissolve again. Another thing that can come here is if LLP is acting against the sovereignty of India. So sovereignty of India means what? Against interest of India. It is not in the interest of India. Again, court can step in, dissolve your LLP. Similarly, if LLP is unable to pay its debts, again court can dissolve, or any other just and equitable grounds, court can dissolve. So these are the keywords which has to come. So that is your section 2B. Let's go further. 3A1, what do you mean by partnership at will? So 3A1, partnership at will, basically has 2 conditions. One, there is no fixed period, correct? So we will continue partnership, and when it will end, there is no fixed period. That is one characteristic of partnership at will. And the other is there is no provision for determination of partnership. These 2 conditions have to be fulfilled. If these 2 conditions are fulfilled, then it is called partnership at will. Let's go ahead. Section 3A subsection 2, good faith. we see that partners can be thrown out or expelled on good faith. So the question is, what is good faith? When we say what is good faith, we are throwing out or expelling a partner. Number one, it is because it is in the interest of the firm. Number two, you have given a notice to such partner. Number three, you have given him an opportunity of being heard. These are the three keywords. If you mention these three, that is what we call it as good faith. On these three grounds, we can say there is good faith. This is how good faith is established. Let's move ahead. 3b. So here again, this question was straightforward, predicted yesterday. Consequences of non-registration. Subsection 2 says, even if you don't register, some rights are not affected. What are those? So we are looking at question number 3b 1 and 2. Let us see 3b1. Correct. When we are looking at 3b1, correct, we are looking at what are the consequences of not registering. Not registering means a partner cannot sue other partner, a partner cannot sue the firm, a partner cannot sue the outsiders, and a set off cannot be made in claims. Set off's maximum is up to 100 rupees in claims. So these are some things which cannot happen. Correct. But there are some things which are not affected even though you don't register. What are those? Third parties can still sue you. Next, partners can still sue for dissolution and settlement of accounts. Legal heirs of deceased partners can still sue. Official receiver that is appointed by court, his rights are not impacted just because partnership firm is not registered. And set off of claims can be still made, but up to 100 rupees. These rights are not affected even though you are not registered. That is your 3b. Let's go ahead to 3c1. When we go to 3c1, so there what has happened, we are giving delivery. The term is that when I deliver, you have to pay. I am coming for delivery, you are not making any payment. Correct. Should I deliver? You don't have to deliver. Very simple. A seller need not deliver the good if the payment is not coming, because unpaid seller has a right, he can withhold delivery. Correct. So he is not bound to give delivery, because the agreement is that I will give you delivery, you give me payment. I got the good, you are not giving me payment, I am not bound. So answer is no, he is not bound. See here the question, decide whether S is bound to fulfill his promise. No, he is not bound to fulfill his promise because payment is not coming. He is an unpaid seller, he has the right to withhold delivery. Simple. Next, second, some loan is there of 30 lakh rupees and there's a default of that loan. Correct. And in India, more than 3 years, if you don't ask money, it is time barred debt. But later you yourself came and are promising me that you will pay the time barred debt. Now you are not paying, it is still a valid contract. So see here whether acceptance of time barred debt is enforceable in law. Yes, it is enforceable in law. Why? Acceptance of time barred debt doesn't have consideration. So we have to quote that consideration is essential element of valid contract, but there are certain situations where without consideration also contract is valid. This is one of those situations. A promise to pay a time barred debt even without consideration is valid. So answer is yes, the contract is enforceable. Next, third subsection, A and B entered into supply of unique item. The minute we say unique item, I ordered some customized item, only you can make it, and I gave you money or whatever, we entered into contract. It's a very unique item, I will not find it anywhere. Suddenly you are saying you will not give. What can the court do is the question. Court can now, this is again breach of contract, which was again predicted in yesterday's video that this question will come. So breach of contract, what can the court do? Court can give an order for specific performance, a suit for specific performance. Court can order because that's a very unique good, I will not find it anywhere, only from you, and you are not ready to give despite we had an agreement. So court can order you, there will be a suit for specific performance. So court can order you that no, you have to perform, you have to deliver that unique good. So that is suit for specific performance, that is the key word. Let's go further ahead. Question number 4a. Non-owner convey better bona fide title. This question was predicted again in yesterday. Nemo dat quod non-habit, if you have seen my yesterday's video. So exceptions to nemo dat quod, they have asked for 6 exceptions, I guess. So what are the exceptions? Straightforward. So basically, if something doesn't belong to you, cannot transfer to others. But something doesn't belong to me, can I still give someone else a good title? There are exceptions. What are the exceptions? Your agent can, joint owner, a person holding property under a voidable contract, a buyer who is in possession of a good even though property has not transferred to him, he can, an unpaid seller can. In case of estoppel, yes, liquidator, company's liquidator, he doesn't own the property, it is company's property, so property does not belong to liquidator, but he can still transfer. So nemo dat quod non habet means I can still transfer a good and bona fide title even though I myself don't have a title. So these cases were exceptions. These were the words which you had to mention. Let us go further ahead. B, 4b. Partners are there, two people left, correct, and they started their own business. Two questions are asked: can they start a competitive business? See, partners while being in partnership cannot do competitive business. Once they leave, they can do competitive business. So they are saying that rights of P and Q to start competitive business, absolutely they have a right to start a competitive business, no problem. But they should have given a public notice here before going. They should have given a public notice, because any retiring partner has to give a public notice. Second, these people were carrying the business with the assets, correct. That is wrong, because they had to settle accounts for P and Q. So second question, what is P and Q's right in the property? Yes, they have a right in the property, their share should come to them. So from the date of public notice they are no more liable, but up till the date of public notice P and Q are liable for losses, they are also eligible for profits. So until the date of public notice, all the profits or losses whatever, P and Q will get. If there are profits and assets, P and Q have a right in it. But in this case, what happened? P and Q were not given their right. The other partners are continuing the business. In that case, from that day of public notice, they have to pay 6% interest, treating it as a loan and advance. Correct? As per Partnership Act, any advance eligible for 6% interest. So now what is their right? They can recover their property, their share in the business, money with 6% interest up to the date of payment. That should be your answer. Let us go to fifth question. Fifth A question, interesting question this is. Two wheeler sale on return basis they have given. Okay, they have given it on a sale or return basis, and without any confirmation, the person just pledged the property. So what is this? So here sale or return basis, three conditions are there which we need to mention. Suppose I send it to you on sale or return basis, you can accept in three ways. One is you expressly tell me that you like the good, you want to keep the good, great. Or you keep it for unreasonable amount of time, I'll assume that you liked it, you bought it. Or three, you have done something with the good, correct. The key word here is what? You have done something with the good which is equivalent to accepting. Here pledging is that activity. You have pledged the good as if it is yours, now it is yours only, you have to buy. So see the question number 1 in it. With reference to provisions, what recourse does Miss R have? So what can R do? R will recover money. R will recover money, because even though it's a sale or return basis, you did not confirm whether you want it, but you pledged it as if it is yours. So now it is sold, it is yours, I will recover money. So that is question number 1. Subsection 2 is there. Would your answer be different if it has been expressly provided that vehicle would remain Mrs. R property until price is paid? Correct. So if until price is paid, property won't go to you, then how dare you pledged it? So that pledge itself is invalid now. So what can Miss R do? Miss R can directly go to that businessman with whom this pledge has happened and recover the good itself, the vehicle itself from there. So answer is different. First case answer is what? First case answer is, since you pledged it, you have done something with the good which is equivalent to accepting the good, so I will recover money from you. Second case, I clearly told you ownership will not go to you until you pay the price. You didn't pay the price, and how dare you pledge? So pledge is invalid. I will directly go and recover wherever that good is. The good is mine. That is the answer. Let us go further. Section 8 company, clearly we again predicted yesterday about section 8 company. So section 8 company, in fact the previous question delivery also was predicted, delivery and ownership transfer was predicted in yesterday's video. So today section 8 company, very simple. What are those specific things, correct? See here, significant points, explain briefly with reference to Companies Act. So what is significant? Number 1, section 8 company is opened only for charitable, religious, scientific purposes, culture, promotion of culture, health, basically charity kind of things. Main key thing, you cannot distribute profits and dividends to the shareholders. Next, you don't have to use the words private, limited and limited if you are a section 8 company in your name. Government gives you a license on certain conditions. If you do not fulfill those conditions, your section 8 license can be revoked, and in case of dissolution, if you are shutting down a section 8 company, you cannot take your money. All that money will go to another section 8 company which is having similar objects. So these are the key things in section 8 company. Let us go further ahead. Next thing is sixth question A. This question was predicted again, wagering versus contingent. They said insurance is contingent. So what is the difference? Wagering agreement is void, whereas contingent agreement is valid. Insurance agreement is valid. Wager means what? An agreement to pay a certain sum of money based on the happening or not happening of a future uncertain event. Agreement to pay a sum of money, void. Whereas contingent is an agreement to perform or not perform based on the happening or not happening of a future uncertain event. So here performance based, there it is payment based. So wagering agreements are void, whereas contingent agreements, contracts like insurance are valid. That's what you need to explain. 6b, circumstances which lead to the liability of a firm for misapplication. So clear cut, two types of misapplication can happen. One is the partner got the money never went to the firm, partner only misapplied. Second case is money came to the firm, after money coming to the firm, partner is misapplying. Both cases, firm is only liable. Why? Mutual agency, true test of partnership. Mutual agency, this was also predicted yesterday, true test of partnership. Correct? Mutual agency, yes, you will be liable. Getting the logic? Firm will be liable in both cases. That is what is the answer. Final, Mike Limited foreign company. See here, company is clearly said incorporated in India. How can it be foreign company? Foreign company means it is incorporated outside India, but it has an office in India or a place of business in India. Or if it's an online business, there is no place of business in India, but in some mode business is happening in India. That's a foreign company. First definition is that. Now coming to the question, is this company a foreign company? No, it's incorporated in India, has a liaison office in Singapore. So what? It's incorporated in India, so it's an Indian company, not a foreign company. So there ends your 60 marks of law. Compare your answers, evaluate yourself. You will get to know whether you are passing, not passing, how much you are scoring. But if you are scoring great, excellent, congratulations. If you are not scoring so well, don't get disheartened. It's okay, leave it. Don't get disappointed, demotivated. You have to keep the spirit up and keep going ahead with your preparation for maths test now. Cool. So all the very best. I will be soon sharing another video where we will be trying to predict accounts paper. So today I'm very happy that yesterday's prediction close to 70-80% has come true. Hope students have taken advantage of that. Accounts paper, look forward, because maths and economics are MCQ 100 marks. There's no way we can predict. All I can tell you is maths focus on time value of money problems around 12 marks. So get your calculator tricks great. Okay, so all the best guys for your next exam, that is maths. So subscribe to the channel and look forward for the accounts prediction paper. Cool. See you guys. Bye bye. Signing off.